We have interpreted this section and located the existence of the power with the central government. But so far as the decision is concerned, the decision is not on the basis of the existing facts. And therefore, the order passed by the central government is set aside and then sent back for reconsideration. Deeply mentioned about the delay in the hands of the state government also.
Deeply obliged, Lords.
You have mentioned about the delay.
Please.
One more, two more judgments.
We issue the following directions. The developer shall pay a sum of rupees 318 crores 31 lakhs 37,664 only for the entire area of the subject plot, being the fair market value as established by the ready reckoner rates applicable to Sector 30A, Vashi, Navi Mumbai as of November 2014. The amount already paid by the developer towards purchase price of the subject plot at the rate of rupees 10,250 per square meter shall be duly adjusted and deducted from the total amount payable. The developer shall additionally pay a sum of rupees 1 crore in lieu of obligation to develop on plot number 40, which remained unfulfilled, subject to payment of the aforesaid amount within a period of 4 months from the date of this judgment. Allotment of subject plot in favor of the developer shall stand regularized. Needless to state that dispute with regard to plot number 39/16, which is subject matter of WP number 368 of 2015, shall be decided by the High Court on its own merits. For the reasons set out above, the impugned common judgment dated 20th November and 21st November passed by the High Court is modified. To the aforesaid extent, the civil appeals are accordingly disposed of. There shall be no order as to costs.
Bhatia committee report is accepted. Additional 15%.
So we have required the builder to pay an additional sum of 55 crores 44 lakhs 37,664 in view of the Bhatia committee's report.
That is.
You want to Malalu say about GST also? These are with GST.
Not now.
That means I come in.
In view of the preceding analysis, the impugned judgment and decree dated 11/11/2022 as corrected on 16/12/2022 and order dated 25/9/2018 passed by the commercial court substituting the words compound interest in place of simple interest for the pendentilate period is quashed and set aside. The company is held entitled to simple interest at the rate of 21.675% for the pendentilate period. Accordingly, the appeals are disposed of. There shall be no order as to costs.
Much obliged.
My lord, there is a direction, my lord, to list in February, second week, my lord. There is no date is showing, my lord.
All right, we'll do a date. Next.
Any date, my lord?
What is this? 10802?
Please, Millets, in item 802 IAPF for the petitioners, Millets, this matter was listed last on 19th of May, but it did not reach. Millets, it's ripe for final arguments if my lords may have it before the vacations, Millets.
All right, we'll give some date. Item one.
I'm so grateful, Millets.
Lordship's leave. Firstly, my apologies. Yesterday's item, and your lordships were kind enough to pass it over for at my instance, but that wasn't part of it. Your lordships indicated the matter may be considered to be listed this week because of the students' interest. May I request for listing of the matter on
Today's
Friday?
matter
Yes, madam.
We have been adjourning this for so many times, Mr.
No, madam, this is regular students, regular
Reason
admission.
or the other. We'll see because
Friday, if
too
it's
much of-
possible, madam.
day after is a holiday.
Friday.
And now in some courts, they have
It will take exactly 15 seconds.
added about 90 matters in courts, huh? 90 matters.
It will take
We'll
60
try,
seconds.
we'll try.
Friday.
Thanks.
Yes.
My lord, may I mention, my lord, a matter where the lordships have admitted the appeals and my lord
Sorry?
directed that my lord, whatever the subsequent developments that will be subject to final outcome. I have filed an application in that for directions. Would my lord direct it to be listed anytime, even during vacation, I have no difficulty.
Whatever, you put it up in the mentioning list. We'll see.
Lord, it is
You
not
won't
coming in
remember
the
that.
mentioning list. That's my difficulty. Therefore, my lord, my instructing advocate tried it twice.
Check it up, check it. Up. Next.
Your lordship.
If it comes tomorrow,
I
we have no
rejected twice by the court. Let it come in July anytime, no difficulty.
We'll see.
Twice. Their idea is to
Made-
delay it and therefore, my lord, I am moving.
We'll see. Next.
Please,
With your lordship's permission, may I mention a listing of an IA, MA, your lordships, for in a disposal of matter where an extension of time period was granted to dispose of the stocks. Your lordships, we wanted listed on this week, your lordship.
Your Lordship, I want to mention one IETS for directions. I filed it last week. It may be listed this week, Your Lordship.
Not possible this week.
Then immediately after vacations, Your Lordship.
Yes. Give the details, madam.
Was the state a circulated letter at this matter?
Yes. As per the letter.
That time they are taking time.
Whoever circulated the letter.
Item 2.
As
Easy lordship. Lord, these were two suits.
concurrent. Completely concurrent, huh?
Lord, they're not concurrent, Lord, with due respect. There are two suits, my lord.
Achha, second suit is.
The second suit was concurrent in my favor.
Yes, the second suit is.
Were concurrent in my favor.
First one was possession.
First one in their favor
Correct.
on the question of. So therefore, this conflict has to be my lord, resolved. High Court on
Your suit was for joint possession, right?
yes
And their suit is for declaration.
for declaration of civil death.
Declaration was allowed.
Civil death. No, that was dismissed, my lord. Their suit was dismissed right up to the High Court.
But the
High Court reversed that.
by the High Court. Is seen for such a long time, and how can they?
My lord, I have the documents with me. I have the documents with me.
What saying what?
In fact, I've got, unfortunately, these are all illiterate people. I've got the death certificate even right now with me of this man in 89.
So what's the declaration is about? Declaration is the High Court.
Lord, what happened was, may I just submit? I came to the court saying that there's this power of attorney in my favor. The man was in Burma. We had also were in Burma. He gave this power of attorney. Actually, it was a deal to sell the land. So I sold the land to my family.
You have documents? to
Yes,
say that he
all
is alive,
documents. Yes.
That he is alive.
Yeah, I've got the death certificate with me. If I have not placed it on record,
It
but
also works out to a declaration that he is no more.
no, no, that is their case, not my case. The problem is the
Is
two
it
cases
not-
got mixed up.
Asking you a simple question.
Please, Lord.
Is it your case that he is not dead?
Lord, on the date of the power of attorney, he was not dead.
Then when?
The court has declared him to be civil death because nobody saw him in the village since 1965. He's living in Burma. All documents are executed in Burma.
Date and execution is taken.
Lord, they're on record. The power of attorney is on record. I can
They before the trial in High Court.
No, my lord. Before the
You are setting up before us a first.
No,
Yes.
my lord. These are all exhibited in the trial court. I've just brought the original with me.
It shows a ground.
Yes, ma'am.
First appellate court that
Yes.
you have already executed the.
Yes, my lord, trial
Why
court.
did that mistake occur in the first appellate court?
Lord,
And also before
what happened? May I just submit how it happened? They filed their suit. Their suit was dismissed. I filed my suit. My suit was allowed. They both went parallelly up to the High Court. The High Court has now allowed their suit and dismissed my suit.
Correct.
Findings of fact. That's the problem.
Your
But
suit is a simple suit for possession, that's all.
possession on the basis of this power of attorney and the sale deeds executed in our favor. That's the reason. Lordship may
It's
just
a declaration only. But
Yes.
then you are only on the point of declaration.
Yes, sir.
So far as that declaration is concerned, you are saying that the finding is wrong for the reason that the man was actually
Yes. Yes,
alive on
both.
that date.
Yes.
But then that evidence was not there before the trial.
It is all there, my lord. The power of attorney, they challenge the power of attorney also.
Where is this
Yes,
document you are
yes.
relying on?
Yes, my lord. May I just show to your lordship? Now, the document is P1 before your lordship. It is exhibited in the trial court in both cases. Lordship may just turn to page
Where
60.
is the reference to that?
Page 60, my lord. Sorry, the type portion, I'll just take out the type portion right now.
What is the document you brought to show it to us today?
Yes, sir. I'm just taking the.
Yeah.
In fact, the courts have said that the power of at page 9, my lord. Page, para 9, page 69. May I read, my lord? Now the power of attorney exhibit P1.
Not that, but then the document which you are saying, which
This is the one, my
evidences
lord.
this fact.
This is the one. This is exactly one. That's what's happened, my lord. The High Court itself has confused all these things.
May I just say one thing, Your Lordships?
61.
Please, your lordship. Page 69, the type portion. Now the power of attorney exhibit P1 is a document which has not been authenticated by the notary public. They're going on to that point, which is also incorrect. That's why I brought an original copy with me to show everything.
Wow, did you say so? So then what happens to the first appellate court?
The first appellate court also decides against them. This I'm reading from their judgment. The High Court reverses it by saying that this
Before
is
the
a
High Court
suspicious.
show the reference
Yes.
to this document in the High Court.
Yes,
judgment.
yes,
It's not a
Lordship.
small judgment, it's a large.
May I just turn to page
20.
page 19 and 20 minutes. The entire discussion is on these two documents. May I just, Lordship, may allow me to start from page 18, right bottom. A perusal of the evidence also shows that even though the documents were exhibited before the trial court, however, the mode of proof and due execution was objected to by the appellant plaintiff in RSA numbered so and so, and no observation finding was recorded by the courts below with regard to objections raised pertaining to mode of proof. The execution of the general power of attorney dated, this is the first one, 12th of December 78 is undisputedly before the public immigration officer who is not any of the authorities officers stipulated under section 85 of the Indian Evidence Act. This is in Burma, not in India. This is in Burma. And the only document which would fulfill that said requirement would be the document executed in 28th of September 1982. This is the second power of attorney. However, the proponent of the said document, general power of attorney dated 28th of September 82.
So that's not properly authenticated, is what.
The second one is properly authenticated.
First one is gone then. First one don't mention about that. Second one is what?
Second one is another power of attorney by the same gentleman. What happened was there was a dispute going on in the village. They were saying no power of attorney, so he got this second one also, in which he authenticates the first one. They just point out that he's a.
What is the date of that when you have taken and produced? When
Yes,
did you produce?
20th of September 82 is the second one. The first one is
No, 82, all right, but when
20th of
was it
December
taken?
78.
When was it taken?
Well, it was taken sometime
September
around 82 itself. And then
September 82.
there
By
was
which time
civil
the trial
proceeding.
court gave its judgment.
Yes, bro.
Well, trial court already gave its
But
judgment.
trial court held in my favor, in my suit. That is the difficulty.
You marked it in the first appellate court then?
No.
Additional
Trial
documents
court
then.
order 41 rule 27 was allowed, went back to the court, and then it was done.
Trial court. Then it dismissed in 84.
Yes. That is their suit. The confusion is about this, their suit and our suit. That is what happens. And the High Court was dealing with section 41.
What do you say?
May I just say one thing, Your Lordships? The High Court records that when this 82, the 78 GPA extra P1 has been concurrently displayed by all three courts. That an extra P1 that Your Lordship saw, concurrently displayed by all three courts. Now, this is a 1982 GPA. Sorry, I'm so sorry, Your Lordship.
That is the point that he's raising. That
Yes, so now, Your Lordship, the second aspect is the 1982 GPA, which is the learned seniors arguing. The High Court records that the person who has executed the GPA would have been 103 years old at that time. He was not seen for the last since 1965. And at page 19, if Your Lordships has the impugned judgment, it records around 7 factors why that GPA cannot be believed. If Your Lordship just has page 19 of the judgment.
sorry, sir. Leave it at that. Dismissed. Next.
Obliged.
Item 3.
The petitioner was decategorized, my lord, from the post of a head constable to the ministerial staff as early as, my lord, 2013, my lord. He, my lord, joined as promoted as head constable 2006. My lord, he has succeeded in all forums, my lord.
Writ petitions are still pending.
No, my lord. Writ petition, my lord, for implementation of the orders of the Honorable High Court, my lord. Confirm the division bench. Because it was due for superannuation on, my lord, February 2026.
You have filed another writ petition.
No, my lord, that's the pending writ appeal, my lord.
Which is
Because,
pending.
my lord, pending writ appeal, my lord. My lord, what has happened, my lord? There was a delay in disposal of the writ appeal, my lord. My lord, I have won in 4 forums. My lord, I won in 4 forums.
So much of a hurry against filing a contempt order. Just wait till the matters get over. The other matters are pending, but should not be. Contempt should be taken up after all the remedies are exhausted, not just the drop of the hat. Thank you. Dismissed.
My lord, the liberty, my lord.
What liberty you want? It's already there.
The contempt, there is a liberty, my lord.
All there. It's already there. What the High Court has granted. Next.
Then I'm permitted to withdraw, my lord.
Okay, dismissed is withdrawn. Yes.
May I please, your lordship?
So much time to even understand what you're trying to do.
May I please, your lordship?
What you want?
I may be permitted to appear as party in person. I am the petitioner, your lordship, and I am a heart patient. And the delay application is there because I applied for the CD in 28 August 2025. There was delay in obtaining the certified copy. I said the delay was the reason.
Vikarabad and Chevella,
Yes.
within the Telangana area, hardly any distance.
Yes, your
I
lordship.
could have you
Your lordship may say page number 112, wherein the Dr. Jaishankar cardiologist. I am a heart patient, your lordship.
No,
My
that is a
pacemaker
bit of
doesn't
personal-
impulse
that's
once
a bit
in
of
24 hours
personal.
for 2 to 3 seconds. If I travel more than 50 kilometers, I will pass away.
Sorry, sir.
Your lordship may peruse page number 112.
Sorry, we will not do that. Thank you. Dismissed. Next.
As there is an immense threat to my life, your lordship may peruse page number
No,
92, the
Item
health
5.
record.
Yeah.
Lordship, similar matters have been
Correct,
dismissed.
correct.
Office report records
Lot
it.
of the-
Serial number. Grateful. Same order may be passed.
Same order.
Roses.
Letter. There is a letter, Mr. Diwan, here, I believe.
I'm sorry.
I believe there is a letter here.
There was a letter, but they took objection, my lord, so it's in your lordship's hands.
You want to go on?
No, whatever. If your
We
lordship
didn't-
wants to see the papers, there's no problem.
Yeah. No, there is a letter we just didn't, huh?
All right, your lordship may keep it.
Letter.
Yes,
It's there, there.
if you have like.
This will be after the vacation.
Yes.
Wait, please. For an hour, and they have given it.
Yes, Mr. Gupta can.
Yes.
You see, I'll just tell you, I mean, now we are not getting into the merits. The arbitral award has been
We set aside concurrently by 34 and 37.
37, absolutely right. So I'm now not getting into the merits of the case. What has happened is that they have initiated a fresh round of arbitration. They were counterclaimants, and a Section 11 notice has been issued. So I'm just requesting that should not be precipitated till your lordship considers the matter.
My lord, we'll have it adjourned, my lord.
Yeah, that's good enough.
That's.
Wait, please. Lord, I am non-suited on the ground of Section 10A. Lord, Section 10A provides for a suspension period, Lord. It says
During COVID period.
during the COVID
Bahar is
period.
that?
Now, what happens, my Lord, when the default continues post that COVID period, that is post March 2021? There's only one judgment of your Lordship's court, Lord, which dealt with a case where, my Lord, the default was within the COVID period and
Ramesh,
that's right.
Versus Siemens.
That was a case, my Lord, where the proceedings was filed within that period. Consequently, my Lord, the question never arose.
We can't interpret it so strictly as if it's a statute. It's a calamity. It's a kind of a.
Precisely, my Lord, that
It's
does
during
not,
that period.
my Lord, that does not give a license to a company to commit a default and then remain in default. Even after the COVID period, my lord, today we are 4 years after the COVID period, no money.
Also at the same time, these are IBC proceedings.
These are IBC
These are
proceedings.
not recovery proceedings.
Lord, it's a financial debt.
It's not recovery proceedings.
Lord, the question will perhaps require your lordship's consideration.
Yeah. That's right. The period is 25th March.
There is no dispute.
6 months from that.
Yes. My lord, in fact, the period stretched on till March 2021. My lord, pursuant to notifications issued by the central government.
Statutory recognition of COVID.
That's right.
So we will liberally construe it.
My lord,
not strictly construe it.
which is why I say, my lord, it's not the question of date of default. Incidentally, the date of default falls within that period, no difficulty. Therefore, my lord, there is a moratorium or a suspension. That's the language of section 10A. It says suspension period. Now, suspension, my lord, means that during this period, there will be nothing. Thereafter, it can be. That's the nominal heading of the section. Just have a look at section 10A.
It occurred, it happened during that period, but
Yes.
it might have extended. You are right.
Yes.
Okay, all right.
And my lord,
Both the NCLT and CLAT also.
Lord, the dichotomy created is that the NCLAT recognizes that for the
It's only a sunset clause. These situations won't occur more because you won't find situations where COVID period exemptions will arise in times to come.
not too many. My lord.
No, it's sunset.
Virtually over. It's worked itself out in that sense.
Try other.
But, my lord,
Thank you.
very good. Please.
Eight.
Have that.
Because I beg to appear virtually, my lords. May I begin, my lords?
Yes, sir. Begin.
Yes, my lords. Boss may kindly have, my lords, para 7 of the impugned judgment, my lords. My whole case was, my lords, that the presumption of, my lords.
Document, you will say it's a presumption.
Yes, my lords. My lords, para 7 may have that, my lords, the substantial question of law, my lords, which was framed.
That was the very document which fell for consideration before the trial, first of all.
Yes, my lords. Yes, my lords.
All of them have held that it's a forged document.
My lords,
Findings of
my lords, there is, my lords, concurrent finding. There's no doubt on it, my lords.
only a fact, no law here.
My lords, may kindly appreciate, my lords, that this section 90 presumption is there. The document has to be, my lords, in a proper custody. And my lords, High Court in the second appeal records that it was in a proper custody. There was no doubt about it. My lords may kindly have para 24, my lords.
Sorry, sir.
My lords may have para 24, my lords, for a moment.
Yes, sir.
My lords, kindly see this.
Yeah, thank you. Next.
My lords may kindly have.
Item 9.
Please, Your Lordship. The High Court holds everything in my favor, my lord. And then as far as equity is concerned, my lord, holds against me in favor of persons who have purchased, my lord, pendant elite and who are not even pleaded as bona fide purchasers. Lord, even if they had pleaded.
They allowed it to the extent of partly allowed and granted you refund.
Lord, money that I paid way back, my lord, in the year 98. I have been in possession, even according to them, my lord. And then, my lord, those people they are the people who are relations, transaction within the family, my lord. Within the, Lord, your lordship looks at the equities, my lord, the way the equities
is completely in their favor.
Pardon, my lord?
Equity is in their favor. Also.
No, my lord, they have not even pleaded their bona fide purchases. Your lordship may have a look at that. In case they are bona fide purchases, of course. My lord, even if they plead as bona fide purchaser, they have to prove it because the onus is not on them under section 90.
Look at this agreement of sale of 1988. So it is filed in 1996.
No, my lord, because there was a permission to be obtained. Permission to be obtained, my lord, a suit is held to be within limitation.
It's a bar.
No, my lord. No, my lord. My lord, though they had to take permission, my lord. He did not even inform. My lord, as far as limitation is concerned, my lord, both the trial court and High Court, both of them hold in my favor. For a minute, as far as the
But they would have given you the money.
Pardon, my lord?
If they had given you the
money
you had deposited,
I did not. Money is, my lord,
not been given by the High Court, but you got it.
My lord, page 219 for a minute, my lord. Page 219. Trial cost consideration, my lord, the High Court also concurs with this as far as the purchase is concerned. Page 219 for a minute, just a minute.
Yes.
Page 219.
Yes,
Top,
read it.
as rightly pointed out by the plaintiff's counsel, that is me, the only defense available for the subsequent purchaser under section 19C is that they are bona fide purchasers, but their contention has not been taken in the written statement. Under the circumstances, it has to be considered by virtue of the admission given by DW2. Paid 12 million, even if High Court also says that. And they are relations. You pass on during the pendency of the suit. This is the very easiest way to defeat.
Thank you.
Very well. As your lordship pleases.
Item 10.
Madam, the Honorable High Court, my lord, without going into the legality of my lord subdivision of the reservation seats, my lord, that is 3% horizontal reservation given to the.
What's prohibition there?
So
What's the prohibition? Horizontal reservation is always like this.
No, my lord, it has to be, my lord, 3% in each category. They have subdivided this 3% reservation into 1% in different three categories. It is reducing the seats, my lord, every year, my lord. Otherwise, my lord, may kindly have, my lord, page 24, where the reservation policy, there are page 24 of my petition.
On the whole, it works out. On the whole, what they have done is, they have actually, it is for E.V. Chinnaya, once the moment it got referred to, that larger bench principle is that subcategorization, there is no anathema against subcategorization. It's legally permissible because it goes and inures to the benefit of identified categories.
Well, ultimately, every year they are reducing the seats, my lord. Every year they are reducing the seats. My seats should have been 23. They are giving me 7 seats.
Not on the whole, they are giving 3%, right?
No. That's my reason, my lord. They are only reducing it to the 7 seats on 25, 26, my lord, by compartmentalization into 1% in each category. My lord, may kindly have.
Not the case. The case is that 3 is subcategorized for general, scheduled caste and backward class into 1%, 1%, 1%.
It amounts to reduction of the seats, my lord.
It's not.
Because my lord, kindly see, my lord, kindly have, my lord, page. My lord, kindly have page.
If you subcategorize, it will be more.
It is ultimately reducing the seats every year, my lord.
Thank you. Dismissed. Next.
Please, Mulaj. In this matter, Mulaj, the High Court has been misled, Mulaj. Petitioner is also one of the Gramnees who have been appointed, but there has been a submission on behalf of the counsel for respondent stating that both the plaintiffs have been appointed as Gramnees. Lordship, may I kindly have page 5. Page 5 of the implement. Mulaj, this is an Mulaj, they don't have locus to file the representation. Mulaj, we are managing, we have a trust. We are managing the suit schedule properties under the trust. The trust also includes 4 temples. Mulaj.
Whether they add more number of plaintiffs or less number of plaintiffs, how does it matter to you? The court has not said anything about the merits of the matter. They
Mulaj, no notice has been served to none of the 60 Mulaj, concerned permanent residents. Mulaj, that is one of the mandates.
How does it affect you?
Mulaj, we are the persons who are in charge of the trust. Mulaj, I am the vice president of the trust who is managing the suit schedule properties. Mulaj. Lordship, may kindly have page 5.
Nothing in this.
Mulaj, may kindly have page 5. Mulaj, just one indulgence. Mulaj, a delay may be condoned.
Please, my lord. The only question is, my lord, whether the statement in the plaint, my lord, which otherwise was vague and speaking to the notice under section 106 was sufficient for the purpose of 711.
Whether it can be gone into, madam.
I bow down, my lord. Otherwise, my lord, would your lordships consider issuing notice only for the purpose of mediation? I'll be very grateful. I've been in the property, my lord, since 2019. I'm running a business from there. My lord, we are hopeful, my lord. We've been there. We've made several improvements to the property. It's running commercially as a hotel. That was my request before your lordships. If your lordships can give us, it will give us an opportunity to try and bring a quietus to the matter.
It will not work because it will not work.
Then I may be permitted to withdraw. Great. I'm grateful.
We thought of sending it to Samadhan Samaroh, but We were just thinking, but I don't think it'll suit his spending.
If your lordships will give us an opportunity, we'll try it because it'll.
You are a tenant from which year? 2016.
Twen-
I don't think it'll work.
See, the difficulty arose during the COVID period, my lord.
Oh, long way.
Can I withdraw? I'm grateful. I'm grateful.
When mandatory provisions are laid down, your lordships are prima facie found in a batch of other matters that SAT, not having inherent powers like a superior court of record, can't vary mandatory provisions.
70 through of the company. There is any statutory appeal in. Issue notice.
No, we require stay because there were directions were from point 2 to point 16. What the court has done is they've set aside those directions. No, what will happen is they'll dissipate all the assets.
Very reasonable order.
No,
The
just
interim
see,
director-
my lords, if your lordship just sees the directions.
Just listen to us.
Well,
Interim order seems to be reasonable, but take out dusty notice. Once they come, we'll consider. Issue notice also on interim application, just immediately after.
and no, instead of if your lordship could give a returnable date,
We will give it.
Well, deeply blend.
Wait, please, my lords. My lords, against the impugned order, the assessee is on appeal.
yes,
The merits, that is, we have filed an up.
To notice post along.
May only pass the order.
Yes, post along.
Very good.
My lord, in this matter, we have received possession of the property 8 years after the allotment. We paid for 2 years, my lord, 21 lakhs. 8 years later, the possession was given in 2019. And in 2020, my lord, we were asked to execute the lease.
The cancellation, your writ is still pending.
No, it's not pending now.
Yes, my lord.
It's not pending, I'm instructed. It's not.
As per their own.
Pending.
Yes, my lord. As
is
per
not
their
pending.
own list of dates.
When did it get disposed of?
As per own list.
Yeah,
of
your lordship
dates,
gives me a
list
list.
of dates.
Writ petition in 2021, which was disposed of. This is a writ petition in 2020.
Sir, against the cancellation in 2023, you filed a writ that's still pending is what we thought. Anyway, it doesn't matter.
Your lordship, otherwise your lordship will take it to be withdrawn or dismissed if it has not been done so. I made that. I believe I'm instructed that it has been done. It's been disposed. No. This order, the revision was in our favor. May I just explain the facts? Lordship gives me 2 minutes.
You are right. They have concurrently filed.
The factual finding, let me just explain the facts in 2 minutes, then thereafter your lordship will take a call, my lord. 2011, the allotment was made. It was for a nursery school. My lord, the policy is very clear and the allotment is very clear. Immediately after the first allotment, my lord, we have to.
Provision.
21 lakhs we paid. Out of 60 lakhs. This problem need to go in. Learned judge has gone into the merits, my lord, in detail. The court. I'll tell you, Lord. May I? Lordship gives me 2 minutes. I'll just tell your lordship the fact. The ground. All right. The ground the High Court dismissed it was as if I have to pay the entire installments and then only I'm to get possession. Policy is very clear, my lord. I have to get the installments are deferred if I'm not given possession. May I just hand over the policy of the government? It cannot be, my lord, that
on the ground of suppression.
No, sir. Then they went to the merits, my lord. This suppression we have said, frankly, we have said we consider it should not have been done and it was inadvertent act. We have said so. But after that, my lord, the court has gone into the merits. Kindly see the merits. The court has held.
Then you are a defaulter now.
No. Now, may I answer that? I am not a defaulter. May I answer that? May I hand over the policy?
Only running page 7 of the impugned order.
We are in your favor.
Very well. I'm not. I have said that. I'm sorry. My mistake.
Yeah, asking you is, you are appearing for whom?
For the authority, my lord. Not greater order authority.
What I want to ask you is that he exercised the revisional power.
Yes, my lord.
And the revisional power was exercised by the principal secretary and restored the plot.
Yes, my lord.
And then in 226 that you have filed,
Yes, my
The
lord.
High Court set it aside. That's a government's decision. That
That's right.
divisional authority's decision is a public authority's decision.
Absolutely, my
Public authority says that the plot must be restored.
Yes,
Also,
my
the High Court say that some
So-
suppression or something.
So your lordship may see only page 7, the impugned order. It says they have two remedies, my lord. They have two remedies. One, they can go in writ petition. Another, they can go in revision. They exercise the right they went under revision petition, my lord, which is still pending.
People will exercise remedies.
So, my lord, that
is ensuring that their rights
your
are
lordship,
protected.
that is still pending. That
I think
writ
the
petition
private
before
party
Chief
can
Justice
argue,
is
cannot
still
do.
pending. And while it is pending,
Take notice, stay. Notice.
my lord, your lordship may be here. My lord, the interim relief that they are seeking for is a final relief, my lord, because they are saying that
You might dismiss it tomorrow.
that's
What is the interim relief?
My lord, that will attain finality, my lord. It says that order of the High Court, the writ petition should be set aside. In the meantime, set.
No.
Yes, my lord. This is what.
State. Kindly see page 29.
What does it mean, my lord? That means the revision petition will come into.
Are you in possession?
Yes.
Status quo.
Obliged.
Status quo, my lord.
Obliged.
Deeply obliged.
My lord. My lord, this is a first appeal from a judgment and final order from the NCDRC, my lord. 60. Item 60.
Yeah. No negligence is the finding.
Yes, my lord. My lord, this is a first appeal.
Wait, appeal admitted.
I appear for the hospital, your lordship. There is a medical council order as well as the West Bengal Medical Council, both of them exonerate.
See, NCTRC first appeal, at least one appellate forum he should get, no?
Very well.
Appeal admitted.
I'm so grateful.
Lordship, the other respondents are not served. I may appeal for only one.
Issue notice. We appeal admitted, issue notice. Issue notice के खिलाफ जो भी है.
So great.
My lords, my apologies that the arguing counsel is not here. He is not well since last evening and due to medical emergency is not.
We'll have it later. Next.
Please.
Grateful, my lords. Sorry. May it please, my lords. My lords, the High Court has rendered a finding that this is a change of opinion. Now, my lords, the first submission would be
These
that
kind of cases won't end, is it? Legislative change should be brought, isn't it? Some measure must be taken. We were discussing it, Raghavendra also. Change of opinions. We are not.
There is a change. I pointed out to my lords, there is a change under the new act. It has made it an objective test. But these are all legacy matters.
Leave the legacy out. For future, good luck.
I'm sure my friend's case has merit, my lord.
You have a rightful intervention.
no, may I only make one submission?
Yes.
That the material
2018, no? 1718
17
assessment.
assessment, yes,
2024, you open your eyes.
yes, 6 years, which the Act permits us to do.
All right.
Now, the only
Not in
test
this
is
case.
whether we had any new material which was not provided to us by the SSC. Now, how did we find this material in this case is because of a search conducted. It formed part of no record submitted by the SSC and therefore a satisfaction was drawn that in this, I leave it. 19, we have not appealed against the order that.
Similar reason. Yes, best. Correct. 20. Please.
Obliged. My lord, similar matters are pending, my lord.
Yes,
It's a
that's
batch.
right.
I can hand
D,
over the
D, right?
lead matter.
Similar matters are pending.
Similar matter.
Assessment year 3445. 34 they have not challenged. Tax effect is only 25 lakhs.
Yes, but this comes under our exceptions, my lord.
No,
Yes.
So if
That's
similar
because
matter
it's
has
a-
been issued notice, what do we do?
in fact,
Even that is low tax. Even the one which
No, this is, I'm sorry, this is a DTA matter. There is a carve out for us in our monetary limit circular for DTA.
only in TDS cases there is a carve out. Otherwise, there is no carve out.
There is a carve out for international
But if I issue
taxation.
notice, I'll answer both the
Certainly.
on delay as well as
Can answer, we will dismiss it, right?
Yes, yes. So, my lords will
By
see.
future.
I'll show my lords the exception, my lord.
Tell us.
Yes, my lords will see the exception.
The only question is,
Yes.
in law,
Yes.
interest income of a PE.
Right, interest received by a PE from the head office.
Head office.
25 lakh rupees only.
No.
No, just for the,
Only 25 lakhs.
Is the interest you receive.
Yes.
no, that is what my,
We'll come back to you. Okay, it's on, but on a principle, what is it?
On a
Whether it is
principle,
taxable or not.
Supreme Court, they followed the Supreme Court saying that there is no distinction in law between a head office and a permanent establishment. It's payment to the same person.
If there is a PE,
Yes.
then obviously it will be subject to tax.
No, that's
There
correct.
is no PE, then there is a problem.
No, that's correct, my lords. The point is that if my lords will see the impugned order, it says Kikabai says, Supreme Court says that a payment to a self cannot be assessed under the Act. Under the treaty is a separate story, my lords. We don't go under the treaty. It is only taxability under the Act, my lords. And my lords, it's a common order. Assessment here 3-4 and 4-5. There is no finding for 4-5. It relies only on 3-4. 3-4 they have not challenged.
Why have you not
so
challenged?
when I say connected matters are pending, if my lords can just.
Report have you
page three,
challenged or not?
I'll have to take instructions.
What instructions?
Can I just say one thing?
You can't just
My friend is
random
talking about.
pick up and then file.
No, I'm sorry. My friend is on question 5. I'm on questions 1 to 4. If my lord can see para 1, those have been dismissed with reference to a connected matter which is pending before my lords in the case of the same SSC. So leaving aside 5 for a minute, that's all I'm asking for today.
Post
Let it
along
go.
with it. You argue
It's-
both the matters.
It's 26 crores is the tax
When is it
effect
coming?
cumulatively. My lords, the last order was
Anyway, post along with it.
7210 of 22.
We'll hear,
Civil appeal.
hear both of them together. 21
Oblige me.
later. Huh?
The most unfortunate case, I've been betrayed by my own son. Now that he does not even appear in the High Court. When we file the appeal, the High Court notices that he's served, he doesn't come. That also shows his conduct. And we have been vigilant. Yes. I've also been vigilant about my rights. I appeared in the suit, I contested it, I filed the first appeal. Why would I leave my property at the second appeal stage? That I am.
You and your son, is it?
He's my son. Number 3, respondent number 3 is my son. That's what my case before the High Court was also. I entrusted him with the litigation. He never bothered to tell me. When I find out, I go and file the appeal.
Ownership is all concurrent all through.
Please, Manoj.
Only injunction revised in first. Ownership is concurrent all.
No, ownership is concurrent finding, but my case.
What is there? Once ownership is there, injunction.
No, but why would I leave it? Let me at least contest my appeal on merits, Manoj. That's my only contention. If it has to be dismissed on merits, let it be dismissed. After contesting for 2 rounds, why would I leave it like this?
1,325 days.
But that is because I entrusted my son with the litigation. Now he goes and join hands with them. He doesn't tell me. And
Court will not enter into what transactions you and your son have.
court will not enter into it, certainly. But at least that on merits, I should be allowed to contest. And please see, I name him as the
On the
respondent.
basis of whether there is a justification.
Manoj, please also see this. I name him as a respondent. He's served. He doesn't appear in the High Court. The High Court notices that at page 5. Even though he was served, he did not come. That itself speaks volumes about his conduct. At least he could have come and denied it. I'm sorry, nothing of that sort is there. It would have been a different case. Where does that leave us?
Declaration is gone, injunction is irrelevant. Thank you.
Very well. Great.
Your Lordship, I'm just seeking a pass over to Sundaram leading us on the matter. He's on his legs, Your Lordship.
Rashmita.
Yes, Your Lordship.
In this matter, the division bench has set aside the order of the single judge. Again, my lord, the plaintiff has filed the suit for recovery of money against the Dilip Kumar Rungta, my lord. Unfortunately, he died on 7th November 2023, my lord. After that, the legal heirs of Rungta was brought on record, my lord. These are the defendants were the legal heirs of the Rungta, my lord. The case of the plaintiff is that he has given the unsecured loan. Order was passed against the legal heirs to disclose their personal bank account and their assets, my lord. Though the
To be filed to indicate what assets are, but no order is passed.
yes, my lord,
At that time, contest the matter.
that is the only thing that the High Court has to realize. See, these are the legal heirs, not the original debtor. Original debtor is somebody else. So maximum their liability could be only to the extent of his personal assets, not to the legal heirs, my lord. And respondent number 2 is a married daughter living outside my city, my lord. And moreover, these are the unsecured loan which was given to him. So that is the only difficulty. If I have to pay the recently
Attachment. Even an attachment order is also not passed.
attachment order has been passed. Kindly see page 9 to page 19.
You are asked to give an affidavit indicating the assets.
Assets and thereafter disclosing the total assets. Kindly see page 7 for a moment.
Show the order.
Please, my lord.
How will they pass an attachment?
Please, para 7. The respondent will submit the affidavit of his before the learned trial court within fortnight from today. An affidavit of his addition to the affidavit respondent will specify the amount.
Recovery of the money is
Yes, my lord. So only humble submission is
cannot
that
be allowed to approbate and reprobate and all that. Stand that the respondent is not taking this so and so, rejected your stand, cited the case laws. Prima facie made out a case supplement noted balance of convenience. Okay.
my lord,
Much he has done, but then
that there is a direct judgment of this honorable court.
suffer injury.
The
See, look at this. There's no operating portion of the
my
order.
lord. Order
You are
30.
assuming too many things.
I'm not any my lord. Only humble
We
submission.
will protect you. We will say.
Please, my lord. Please, my lord.
Well, we are not inclined to intervene. The petitioner to file an affidavit of assets. Here is the opinion that the court will give an opportunity to the petitioner before final orders of attachment are passed.
My lord,
Especially petition.
and to the disease, my lord, to the personal assets, because
Objections you raise, sir, we will not stop you from any other objection.
before any attachment order can be passed, my lord. My lord, there is one more thing, my lord, which is very important. On para number 18.
Actually, your petition is not even
My lord,
maintainable. Simple asking you to file an affidavit is not a ground for filing an appeal. Thank you. Please,
please, my lord. So not may dispose of this matter.
Yes, we have done that.
Please, my lord. Dispose.
Same order.
Your Lordship will turn to page 22. Half the matter, my lord, is in my favor. It is remanded. For the other half, he says you are belated, which is wrong, my lord. We were not belated. Your Lordship, see para 54, page 12.
So it's a gap between 5% and the
Yes.
other place.
So I am governed, my lord, by Ministry of Power Directive. It's a policy directive under section 3 of the Electricity Act.
Sit down.
It's a directive. See the directive, my lord.
We have given a recently one.
102. I am requesting, my lord, for a short notice in July, my lord, then it can be heard. 102. I see.
Policy decisions of the central government
Will bind.
will have to be taken into account.
That is GBI, yes, yes. Same thing here, my lord. But he has knocked me out on delay, my lord. For half the thing is okay, half not okay.
What's the delay here?
No, he says, my lord, 2017 to 22 regulations came in 17, 22, 27 came in 22, you challenge in 24. Therefore, the first part is belated, second part you are right. And he is also wrong there, my lord. Because the notice was given, I replied.
He's right. You didn't comply in 17.
I didn't comply, my lord.
17 is the APERC regulation.
Yes.
MOP suggestion came only in 2019.
But my lord, it is retrospective. So that is very important, which he missed.
Page 9.
See, my lord, 102. Just see 102. That's what the court missed. In saying you are belated, he is wrong.
Take out note.
Kindly, my lord, just issue notice returnable in July. Great.
Great.
The short point here is, Manoj, the trial court comes to a finding of fact that it's a street.
What does your statement say?
Manoj, my statement says it's a street, it's a gully. The trial court comes to a finding of fact it's a street. The first appellate court says, as the government in any case is a trustee of every public passage. I can show that in the act as well. Our salary street? Really? Our salary or what? P2. Passage closed street.
For Mr.
A closed street, Malaj. My sale deed P2 page 27 says it's a closed street.
What?
A closed street, yes, Malaj. P.
Oh, that's not the story. The other story is that you sought to purchase it.
No. That's my entire grievance is this. The other side. The other. I am saying it's a public street.
Earlier also. The finding is, well, of course, they have purchased it from the government. You are challenging their.
Yes, Malaj.
But then you are talking about the history.
Yes, Malaj.
Your history, which is a very inconvenient history for you.
As of now, all
you
I'm
don't
saying-
want.
Malaj, it's a street which has been sold.
All right. Property is property. That's it. You should have asked for easement rights instead of that. Anyway, dismissed.
Grateful. Obliged.
Grateful.
My lords, in item 27, the limited point is, my lords, the High Court did not consider Rule 32 of the 2008 rules, my lords.
Rule 32.
Please, my lords. My lords, that's quoted on page 7 of the SLP.
What does 32 say?
My lords, where a dealer becomes liable.
Registered dealer.
Please, my lords, it
But
talks
do the
about
sale
an
invoice
unregistered
there.
dealer.
What are the findings against you? It's a High Court allowed, is it?
My lords, the High Court allowed.
Allowed it because you are not registered.
Please,
You are
my lords,
saying
the second appeal considers the fact
Is
that.
there a reference to Rule 32 in the High Court judgment?
No, my lords, there is no reference.
You argue Rule
Second
32
appeal.
anywhere?
My lords, my lords, we could not argue that point before the High Court. My lords, however, it's recorded in the second appeal order specifically.
Okay, learned counsel for the learned counsel for the petitioner refers to Rule 32, which enables an unregistered dealer to have the benefit of sale invoices, to have the benefit of input tax credit with respect to sale invoices. To note it. Is that what you're saying, right?
Please, ma'am.
Input tax credit on the basis of Rule
Yes.
32. Are there any judgments on this point on 32?
My lords, I will try and find out.
Right.
Yes.
Next.
I'm so grateful.
I'm requesting for a password.
So, enforcement of an international law.
What is the one 5 crores?
Well,
About
we are
a little
requesting
over.
for a password. I'm led by Mr.
Password.
2956, both it looks are premature matters, premature petitions. So we'll pursue ex parte orders, we'll pursue before the High Court. Let it be continued.
We should pursue before. How can the High Court even entertain this petition? To pursue it.
Yes.
The transaction is, how can they file a petition in
Mumbai, you could not.
Mumbai?
But it was a vacation time, therefore we moved here. Yeah, we'll look for.
No, not like that. This moving is all completely uncalled.
Yes.
Initially, we thought we'll dismiss it. Because as the previous one.
Yes.
Then you have a strong case, but what
We have moved an application for revocation as such in.
between the application for revocation
Revocation of leave in the first matter.
has already been moved in this of its statement, especially permitted to be withdrawn or dismissed as well.
Maybe dismissed with the liberty to pursue that.
Dismissed as withdrawn with liberty to pursue the setup.
Yes. In 56, it's ex parte injunction. There we have to move the application, but in the same proceedings.
Same. Both actually, they could not have passed that order ex parte.
Correct. They should not have done it. Therefore, we moved it. Only the expeditious.
So, Nataraj submits that 6th April 2026 order is, direction is an ex parte order. Ex parte order, and it is for this reason, further, and it is for this reason that we moved an application for revocation.
Revocation.
In view of the fact that an application for revocation is moved, we are not inclined to hear everything. We direct that the application be taken up and disposed of in accordance with law.
Expeditiously, because it has to be considered.
Taken up and disposed of expeditiously in accordance.
Please, I'm good.
Yes, sir. That
Your Lordship, in item number 30, in item number 30,
reversing
High
judgment.
Court, Your Lordship.
Yes, tell us, Mr. Kataria.
Yes, my lord. My lord, item number 30, the whole issue, my lord, which the alternatively courts are deciding against and in favor, my favor, whether
It's barred. Well, said it's barred, no?
that's what I want to submit. It is not barred, my lord.
It's a
Your
tenant.
Lordship.
You are couching it
No,
as
he is not a tenant. That is the whole issue. If your Lordship may just have page 34. 34 would clarify the thing. He is not a tenant. Your Lordship may just have page 34. However, your Lordship is
yes. Okay. What is there in 34?
at page 34 is the judgment of the district judge, my lord. In an earlier set of litigation between the same parties, they filed injunction suit and the court has not granted injunction on these grounds, my lord. If your Lordship may, this is the final order. However,
14, with section 77.3.
Since when?
my lord, before this, my lord, if your Lordship,
16, sir.
page 34, if your Lordship, just page 34.
Obviously, he's an agricultural tenant.
No. That's what I want to show, my lord. So far as the order is concerned, this provisions are concerned, they are also not applicable in this case. I just want my argument is twofold.
Not for eviction. You are asking for recovery of money.
No, not eviction. I am asking for the damages. That's what I just.
It's a case of damages.
No, my lord. And let me submit, my lord. Let me submit for a moment. My argument is twofold. I'm saying that he is not a tenant. He is only, if your lordship may have page 34, where they say that he was only, from person I purchased it, he was only a caretaker. That's what has been said. I just read to your lordship this portion. However, a careful scrutiny of
2012, from earlier round of 2016, when the respondent himself filed a suit and got it decreed. What was that suit for? It was a suit.
That suit was suit for injunction.
Then
injunction was declined to him on the ground that he was not protected as a tenant or anything else.
Sorry,
Now,
sir, we are not inclined.
yes, my lord. Even if he's a tenant, if your lordship will just have a read section 77, court should have given it to me back to like.
Go on to the Agricultural Tenancy Act and then get it.
My lord, just for a moment, if your lordship may read section 77, it page, my lord. I just want to show to your lordship, my lord.
What has he been doing? What is your relationship with him?
No relationship, my lord. I purchased this land. He was a trespasser on that land.
Then why are you asking for damages?
Damages because he is in occupation of this land.
Position part of it.
He is in occupation of this land for a long time, my lord, 6 years.
Then he is in possession.
My lord, if your lordship may have
occupied, you are asking for damages. You
my
are
lord.
seeking eviction.
For a moment, my lord. For a moment, read the provision of the law. For a moment, my lord. Page H, your lordship may have. May I read to your lordship? Where in a suit cognizable by an institute in a civil court, it becomes necessary to decide any matter which can under this subsection be heard and determined only by a revenue court. The civil court shall endorse upon the plaintiff the nature of the matter for decision, and particular required to order 7 Rule 10 Civil Code, return the point to the presentation in the collect. So, in case even if the jurisdiction was not there, it should have been returned, and the court under Order 7 Rule 10 also, the same provision is there in section 77, where it is to be returned back, and I could have filed before that, my lord. Now the High Court has declined. High Court has said jurisdiction is not there. High Court ought to have passed this order.
Only High Court, even the trial court said, what did you do after the trial court gave that judgment?
Trial court said the jurisdiction is not there. I came in the appellate court. The trial court should have also said, my lord. That's what I'm saying. At that point, I was saying the jurisdiction is there.
All right, we've
Now,
heard. Thank you. Dismissed. Next. They drew a distinction, no? That distinction is only covered actually. What's the present position? No, what's the new tender has been, so even if you give you a notice, what's the point? I mean, how will they help you out? How will we help you out first? Oh, you're saying that at least you are confiscation. Forfeiture, okay, issue notice. Issue notice, we'll confine it to a return of forfeited money. Correct? 132.
Booked the tickets on the 25th of March, right above, and I was not available on the 18th. Now 17th, 20th, I was traveling for.
Adjourned.
What happened? 11th May, what happened? 11th May.
Nothing happened in this year today for judgment and now.
Then you'll file a first appeal against that order.
Shall we take all these grounds? We can take all these grounds in appeal.
It'll endure to your benefit because you set aside the judgment, and what's the point? Perhaps you're succeeding, who knows? Suit is getting dismissed.
And in any case, we can take this ground in appeal.
Exactly. It will be reopening the whole thing. Anyway, leave it at that. Yeah, it's open. It will be open, of course. Why? You have a right of first appeal. Why should he say? No, what do you want us to keep open? That right to file in a first appeal.
This order we can, grounds he can take.
We are entitled to raise all grounds, including the ground relating, including the ground as regards ground about not having an opportunity to contest the case before the trial court. When he files a first appeal against the order impugned judgment.
In case of
In case, see, these are all so many ifs and buts. It's better that we leave it without making any observation. No, it doesn't really. You are entitled to that, isn't it? Why can't we say? What? While we are not inclined to interfere, all questions of law and fact are would be available to the petitioner if he has to file a first appeal against the judgment of that. Yes.
Lord, I beg to appear in 33. Lords, here what has happened is my 9 and 11 both are dismissed. However, it's not in dispute that I'm signatory. What has been missed is, my lord, that this agreement is falling part of the earlier agreement. So we have, my lords, agreement 1 and agreement 2. My lords, earlier agreement on record would show
Only a
that,
confirming party.
my lords, can I say with respect, appears to be a huge error looking at my nature and role because I am a financial
73,
partner.
Page 73.
My lords, yes, my lord. My lords, page 73 is the finding. My lords, I wanted to just show two things. From the agreement itself, it says the entire money is my money. He is my financial partner number 2. If your lordship will, my lord, see two documents, which is, my lord, A, clause from the same agreement, and B, my lord, the referred agreement. I am the one who purchased this property. I have given
We are
one.
not in the Benami Act, sir.
No, no, my lord. It is by virtue of a, my lord's, assignment which has happened in law, recognized by both of us.
Take us through the clause.
Yes, my lord, please. My lords, please have a look at first agreement, which is relevant of which is at page 70. This is dated 30.10.21.
A clause bada confined to
Yes, sir.
confined to only those two. Very carefully drafted document.
My lord,
Carefully drafted document.
Confirming point.
Though, see,
my lords,
point in your favor. Show the arbitration clause. Just
yes, my lord, I thought if I can
think it's
complete the chain by showing two documents, we reach to arbitration clause immediately. Would your lordship permit me that?
Just 1 minute.
Please.
Just come to the clause and then go back to what you want to show.
My lords, clauses though quoted in the impugned itself. Can I show from impugned?
No, no. What the clause of arbitration clause at 70?
The page 80. 80.
Huh?
80. Clause number 15.
Because without prejudice to the above mentioned clause, it's agreed between the parties, it says. Parties will include a confirming party also. That's not. Because parties are, there are three.
No difficulty, my lord.
First part, second part, and confirming part.
Lordship, please.
That way you may be right.
Well, I wanted to show something much more, and my lords, two judgments of this court, which helps me because your lordships have always said what is to be seen is my lord's veritable, namely true party. Who is the party whose money is riding? It is my money which is riding. 1 crore 5 lakh undisputedly I have paid. The first party is my lord, the party who has paid minuscule, namely 48 lakhs only. So it is my money in their hands, and this agreement is after agreement 1.
No interest is left so far as you are concerned.
My lords, I say with great respect, that may not be correct, my lord, for the reason that I am introduced as somebody who is, my lord, giving a finance. So please have a look at in this very agreement, page 75 for a moment. I am a he is my financing party. My lords, the person is my financing party. One paragraph will, my lords, clear the entire. My lords, page 75, top, first paragraph.
Yes.
My lords, I wish to read it. Whereas the confirming party has already executed joint memorandum of settlement dated 30th of October 21, agreement A, related to the said property, according to which confirming party or its nominee shall purchase the said property for 6 crores 50 lakhs from the first party, vendor, and accordingly second party, vendee, buyer, that is, my lords, the person, through its agreement to sell, shall become nominee, financial partner of confirming. I am very much there. He is my financing party, which has come. I am a confirming party in this background. And my lord, this agreement 1 is between me and them. I am throughout pervasively present in the matter. And that's where, my lord, those tests of true parties.
If you see, yes.
Because your lordship has seen arbitration clause of this very agreement.
But this question also can be kept open.
And what am I seeking, my lord? I'm just seeking to be referred because competence,
My lord, there are
doesn't
many
take care.
subsequent development, my lord. There are multiple transactions thereafter leading to multiple litigation in Delhi court and Haryana
Are
court.
there any other arbitral proceedings between any parties pending?
No, my lord, no, my lord. But there are
And you will
different,
raise-
there are
let
three.
then you take notice in this matter.
Well, I will accept notice, but only I am opposing interim yesterday, my lord.
Because interim has to be there.
No, there is no ultimate interim.
Very well,
Will you
very,
raise-
very well.
One-
I will accept notice. No
one
problem.
minute. The question relating to existence of an arbitration agreement also can be seen by the arbitral tribunal. So this question can be answered. You can
My
raise
lord,
it before
that is relegated into background because of multiple transactions leading to multiple suits in Delhi court and Haryana court, and ultimately it is relegated into background, my lord. And what happened, my lord? All the
lot of subsequent
all these facts have been suppressed in High Court, and it had been suppressed before your lordship also.
If you notice, file account.
Very well.
I
Very
have
well.
some respectful submission. What my friend is saying orally was never the part of his.
Not orally, it's a part of record, it's a
If
part
we
of
can
my
figure
record
out-
in High Court.
There are suppressions. We will dismiss with
Because my friend is well. I'm so sorry.
We'll dismiss with cause. You file a short, clear counter affidavit.
I will. I will.
Issue notice.
And Milos gave a returnable
No.
short one so that because Milos, my friend wants to just change
All
the.
right. Come, it will come. Next.
Milos, in July, your lordship will.
So and so takes no. Who is advocate on yourself?
Yes.
So and so takes notice on behalf of the respondent.
Lordship.
Very well. Very well.
Are there any other respondents?
Milos, respond number two.
Respondent number one, but my lord, one and petitioner, they are virtually alter ego.
That's what my case is. Please.
So and so accept notice on behalf of respondent number two. Service is deemed to be complete. This for final disposal.
Lordship.
Counter affidavit you file.
Very well. Very.
Next.
Please.
May I submit? This is the divergent finding of the High Court. High Court very interestingly does not even refer to that part of the decree, which is relating to permanent injunction. My lords have held Khasra Pani is a document of title. Your lordships are aware.
Indication of title.
Yes. And my lords, that stands in my name.
You
Khasra Pani stands in my name in the column of possession. I am protected by a decree of injunction by the trial court, affirmed by the first appellate court. High Court, my lords, travels beyond the question of law framed, which is only relating to title. No question of injunction is at all raised before the High Court.
Issue notice.
My lords, there is a delay also.
How much?
There is a delay of 590 days. There was a death in the family of the plaintiff, and thereafter there was a suicide, my lords. There.
But then 500 days delay.
Yes, Your.
Very difficult to condone. Sir.
Your lordships may issue notice on delay as well as on the.
No, you should explain to us.
I have explained. Kindly see, my lords. I have produced the two death certificates.
600, 2 years day.
Two members in the family passed away. One person, my lords, a young person who was flowing along with the petitioner, has committed suicide, and thereafter, my lords, the mother also passes away because of that. And they are a farmer's family with poverty and illiteracy coming from that.
Who are the dependents to you? Are they related to you?
No, they are not related.
Then their
their claim, they have admitted that they are in, they claim their possession in respect of another hissa of the very same survey number named 251/1, and they admit that they don't have any interest in 251/3.
They are very doubtful.
This is the admission, my lords will.
Issue notice. Special petition as well as the application for condonation is delayed.
I'm grateful. May I, my lord, seek for an interim order of status quo, my lords, because
we don't know. 2 years delay, we don't. You'll not. After they come
no,
back, we'll see. After they come back, we'll see.
I grateful.
I was requesting for a Passover. It's 35. I was requesting for a Passover notice. Malos, the stay is expiring next week, Malos. If your lordships can continue the stay by the High Court, Malos.
Stay.
Because otherwise my bank guarantee will be encashed, my lords. Deeply obliged, my lords.
Wait, please, your lordships. Well, I can't really press your lordships for status quo in this matter because the election has been held and the person has to take. Well, all I'm seeking from your lordships is that my two matters that are pending, the original.
Nagar Panchayat.
Yes, lords, my two matters are pending in the High Court. Let them be disposed of. There's a intent to delay them indefinitely, etc. Let the matters be disposed of. I'll take my.
What do you want us to do in a matter like this?
Well, those.
Because if he can't, he has no right. He can't say that don't hold elections.
No, Mullers, I'm not saying, that's why I said I'm not saying that. Because elections have held, your lordships can't.
While we are not inclined to interfere with the order passed by the High Court, we direct the tribunal to, which tribunal is this?
Well, it's the High Court itself. The matters are now before the High
We
Court.
request the High Court to take up and dispose of the, what is it called? Election petition? What is it called?
Well, it's, there were
Called?
election petitions in which decision was against me.
What is the reference of the matter? Is it called the, what is it called?
Election petition is this.
Election petition.
Writ petitions.
No, it's not writ.
Well, may I just give the numbers, the two writ petitions that are pending, challenging the decision in the election petition.
No, the EP before the tribunal is what you are saying, right?
But the tribunal has decided against me and did two things.
We direct the writ petition to be disposed of.
That's right, that's right.
Expeditious. Right. Good night, direct.
I'm deeply grateful, Manas.
The writ against the thought.
My Lord Senior Counsel Naidu is leading the matter. May I request?
Yes, who is appearing? Mr. Senior Counsel.
Who is appearing? May I request?
What an extent invention can be limited.
May I request short pass over?
What is on his leg?
Who's coming?
This coming.
What, Naidu?
Millets. Where's the couch?
Other side is somebody's there.
Nobody's on KVT.
Party.
Indeed, Millets. It's coming for the first time, Millets. An election petition, a preliminary objection we have raised as to the maintainability.
How, this which item? 31, 30. Next case.
Just tell us something else.
Millets.
Successful candidate.
Successful candidate is the petitioner before lordships, and somebody else has filed a petition raising the plea of corrupt practice and Millets that of using the religion.
Yeah.
Millets, I have taken 4 grounds, Millets.
You've seen it. Each ground is answered. We will issue notice.
Absolutely, Millets. It deserves.
Not absolutely.
Yes. It needs to be stayed, Millets.
Stayed.
Millets, election petition.
Was there a stay before the High Court during the hearing of 711 petition? You show us that.
Millets.
Was there an interim order pending 711? With what High Court has not given, we will not
Millets.
serve it on them.
One moment. Was there any stay before the High Court? Any stay? No.
Then
how much time it took?
Then how for the first time we will grant you stay?
Millets, the problem is this, Millets. At that stage, it was very preliminary. Now they may proceed, Millets. That's to the prejudice because I could demonstrate to your lordships completely.
Mr. Naidu.
Yes, Millets.
2025 matter.
Yeah.
Events are not going to. You all know what will happen in 25.
How election petitions proceed, you know.
You notice also on the
Millets.
application for notice on the application.
To the extent pleadings to be completed, my lords may allow, Millets. Let there be no trial because I have to complete my pleadings either. We have not yet filed the written stay.
Notice on the special petition as well as the application for grant of stay. List immediately.
Millets. Let it go on, Millets, as to the pleadings, Millets. The minus trial.
Yeah, come after occasion. We consider. 38.
Millets, just one.
No.
It's been listed on 1st June, Millets.
No expert here. 2026 matter, Mr. Naidu, what are you saying?
Millets, my lords may know Kerala millets. There, everything is done in 6 months flat.
Get it.
Great.
It's 38.
Great.
Boss, can I
Millets, in this matter,
request your lordships to pass over this matter?
no, Millets, I just pray for something. My lords indicated on the last occasion, why don't you sit across and do things? It seems, Millets, they have given certain maps with regard to the manner of division. Could it be posted on Friday, Millets, so that I'll get
I have no
instructions?
difficulty, my lords.
The council who assists me is not there. He has some difficulty.
problem.
No issue.
So I don't have instructions.
No difficulty, my lords.
Grateful.
But 39, my lord, got nurses who have been selected and subsequently when they change the rules, they want to apply the new rules, not retrospectively, that rule. Not. We are already in the select list. Let the appointment be given subject to outcome. My lord.
Lord, actually, when you're
We,
3rd February,
Ah,
my lord. 3rd February,
yes.
26 order, my lord.
no, we have succeeded before single judge and the division bench. Yes.
Lord, we had tried because your lordships had asked us to see whether a resolution is possible.
Lord, your lordship
We
had
did.
said on 2nd February that everybody should be accommodated.
Yes.
The vacancy-
We have tried.
But my lord,
Everybody started
That's
saying, we
correct.
only said that we will hear the matter. That's
yes,
That's
yes.
correct.
Lord,
Lordships had
here,
said that your
my
lordships.
lords, my lords, the difficulty.
If your lordships are, if your
It was
lordships.
the scene in which we said that we will only have to hear.
That's right.
Because nothing else will happen.
Actually, my lord, we are
Everybody was talking, everybody was shouting. So we thought, in fact, we have said that not before us.
No, please.
my lords,
We said that order, but
No, please don't say that.
no, my lords have not said this. My lords,
My lord, I'll
my-
persuade all my friends to keep their mouths
Yes,
shut.
it has to be heard. Your lordship may hear it today.
Exactly,
Or
exactly.
your
It
lordship
has to
may
be
hear
heard.
it on the opening or
Has to be heard.
we
But,
are ready to go on.
only that.
When shall we list it?
Can we? I was praying last time.
Anytime in
Your
July or
lordships
August.
have said, please don't fill up because we have succeeded in 2 courts below. They shouldn't be appointing and filling up.
There is statutory amendments after
What do you
this.
say, what stage is that?
Yes,
You're
there
asking
is.
him. No, where is, here,
Taken
looking.
and-
Last time also you confused.
Nice.
Yes, what's the stage?
Status
Status quo already we passed.
It's already status quo,
My
is what I'm
lords,
telling
my
you.
lords,
You already passed. it.
very well. My lords, the difficulty is that my lords, the difficulty is pursuant to the interim orders passed by this court.
After vacation.
My lords,
Very
my lords.
Then.
63.
Yes.
My lords, item 63 is connected. Your lordships may issue notice in that because
Notice.
you are
Notice and post along.
And sometime in July.
We are already a party in the.
we are parties in the
We are
SL.
only saying post along with that.
Yes. Your lordships may issue notice, my lords. It can be answered because your lordship's order has been misinterpreted, and that's what compelled this petition.
Lord, would your
Yes, my
lordships,
lords.
consider there are at least 3 or 4 SLBs. There could be conflicting claims. Would your lordships consider there has been an interim
What
order?
had happened, Mr. Green?
No,
What had happened is
Yeah.
that we after long discussion, we said all of you sit down and tell us what happened.
Correct.
And the next time when the matter was called, it was not reported to us what happened, what not. Everybody started talking. And without reference to what had happened, then we have asked a team of lawyers to
We will do one
sit
thing,
and then
Lord.
tell us. So instead of that, it's
My lord,
it's a
we will
fresh
do.
matter. So we didn't know what to do. So therefore, only way to deal with this is to just.
Lord,
clear
we
all-
will do one thing. We will all, just 1 minute, please.
Here all-
We will all sit down during vacation and give a written suggestion which will be signed by all of us and your lordship can proceed on
What
that.
we have told you last.
We will do it. We will do it. We'll do it.
Great.
We will do it.
63 is notice, my lords.
Post along.
Suggestions also to the state.
Yes.
Very well.
Some actual date your lordship may fix in July. In July.
Come in the
In
list.
item 40, I have received a counter yesterday only, my lords, in the evening, my lords. My lords, may I kindly list it on any NMD date, my lords. This requires final hearing, my lords. My lords, the month of July, my lords.
I didn't join. Permission granted, list on July or August.
I am grateful, my lords. I am grateful.
Circulated a letter for rejoinder in this matter, my lords.
You also want file?
They filed.
Yes, my lordship. I am
Please, your lordships. Your lordships, I am
I'm
My
paying
lordship,
for
I
the
seek
short.
time to file counter affidavit, my lordship.
43.
It's for my lordship.
Please, Your Lordship, I am for the petitioner. This is a transfer petition matter of a divorce matter. I had a communication with the counsel for the respondents. They have already filed the wakalat. As per, they were supposed to be in the courtroom, Your Lordship. But as per my discussion with them,
What is to be done? No,
Your Lordship, both the parties are agreeing.
Both
Both the parties are agreeing with respect. If Your Lordship permit the matter to be transferred for the mediation,
refer to mediation. 44.
highly obliged.
Item 44, we moved an IA.
Mediation failed.
No, mediation successful, entire amount done, and I had to pay in installments. My client is just 2 minutes away.
You filed an application.
I filed an application, and I'm paying 9,51,000, which was to be paid in 3 installments today only. Today only, sir.
We'll allow it.
Yes,
Your Lordship.
he's coming with the draft. The total amount was, my lords, the total amount as per the MOU was, 1 minute, my lord, was about 13,51,000, my lords, out of which we have paid for. And yes, my lords, the MOU have annexed at page.
Doesn't matter, sir. We will allow it in terms
Yes,
of
yes, my lord, he's
Your
getting the
Lordship,
draft.
there is a particular, I'm sorry if my learned senior has to submit something more. Your Lordship, with regards to my client, Your Lordship, I agree to the point that we had entered into settlement. However, after the settlement, they have run into rough weather with each other. I guided them that there is a settlement that is before Your Lordships. She's already online, Your Lordship. I have guided to my best ability, but unless Your Lordship says something, sometimes it gets difficult on our part as well. The problem is, Your Lordship, he has gone about defaming her. Your Lordship, I have received letters on her behalf. I'm placing it before Your Lordship.
I'll tell you.
Where is your? Don't tell us, please. We are not.
No, he's in 2 minutes. His flight got.
To just say sorry.
Yes, yes, sir. He's today saying every time he's willing to say sorry in front of the court, he'll say sorry, sir. But sir, yes, sir, he's coming in 5 minutes. Sir, 5 minutes he'll be here. His flight got delayed.
Obliged, Your Lord.
Sincere.
My lord, the letter has been circulated. Not by me, actually. It's been circulated by 2 other petitioners.
This is a clinical trial matter that
Exactly.
Mr. Parikh had appeared, and this requires consideration because today it was listed assuming that it's going to be in NMD millets, but it's now been declared as miscellaneous.
It's part heard
Your
in
Lordship
any
may
case.
fix it any day millets post vacation. Will argue that millets. So Your Lordship has also directed us to file compilation. We have prepared it. We'll file it. Bring it millets whenever.
My lords, could a fixed date be given?
Fixed date. 46.
Grateful.
We filed the copy of the original mark sheet. Yes, my lords. My lords, we filed the original mark sheet. Even I brought it here also, my lords. There's the original of high school mark sheet.
Yes, my lords, they have the plea of juvenility can be raised at any stage. My lord. This is the settled law. I cannot dispute that, my lords. My lord, they have filed the mark sheet of the 10th.
Have you examined it in detail? Prima facie, what do you feel? We wanted your advice.
Yes, my lord.
Have you examined it closely? Because we were routinely doing it.
Yes.
But after some time, this court realized that
Prima facie test. Yes, my lord. The yes, my lord. Your lordships have laid down the prima facie test.
Have you examined it?
Yes, my lord. The document which they have filed is a 10th. That appears to be genuine, my lord. So, my lords, an inquiry may be ordered, my lords.
My lords, through the superintendent of jail superintendent filed the RTI pertaining to this mark sheet, and RTI affirmed the genuinity of this mark sheet, my lords, and that RTI copy has also been annexed with the affidavit.
This will be required to be examined, my lord, because as per your lordship's judgment,
Yes,
yes, yes. 302, my lord. As on the date of offense,
Lords, more than 4 years.
More than?
More than 4 years. Lords, he in custody since 23rd November 2021. It's more than
Normally, these things are raised around 10th year or something.
And then my lord, section. And then only two things, my lord. Section. The session codes, my lord. Of district bus. Two things, my lord. Section 94 requires that it should be a certificate of class. What is produced is a mark sheet. So, my lords, secondly, my lords, the offense is 302, which is a heinous offense. Then section 15 comes into play.
These were concurrent findings, no?
Yes, my lord, up to this court.
Okay.
So heinous offense, section 15
This
comes.
was dismissed and later on we should notice the
Review, my lords.
when was Mr. Sudhailalit should notice it.
Yes, madam.
Additional availability. It is still a review petition which is listed.
Yes,
today.
my lord. This is relative.
This review petition arises out of an order dated 25/2/2022 by which the specially petition filed by the petitioner accused was dismissed on the basis of an FIR which was lodged on 1982, followed by a charge sheet on 6/8/1980. The petitioner convicted and sentenced to life imprisonment by the trial court on 27/6/1983. The said judgment order was confirmed in appeal by the High Court on 24/12/2021. So, when is this application filed? On so and so, the present review petition is filed. Should give us an application. Give us an application. Present review petition is filed. Pleading in the area that as on the date of commission of the offence, the petitioner was a minor.
Yes.
In support of his contention. Then how people for his contention.
22nd July 2022. my lords.
That's the date of
Filing of the review petition.
date. Okay, tell the date.
22nd of July, my lords, 2022.
By its order dated. The review petition is filed by its order dated 2/11/2022. This court issued notice on the review petition. We heard Mr. Bhakti Vardhan, counsel for the state of UP, having considered the matter in detail. We are of the opinion that the plea of juvenility needs to be investigated. This view of the matter, we direct. This is the trial court. We direct
It will be additional session judge Basti.
to inquire into plea of juvenility and submit a report by 31st of August 2026.
I'm grateful.
Grateful, Lord. The counsel is appearing virtually, Manoj, on behalf of the appellant.
My lord, I am for the R1.
Let's I am appearing.
Appearing through VC.
Lords, I am appearing for the respond number 1, my lords. I am indisposed, my lord, therefore I am seeking your lordship's indulgence. If the matter could not be heard today, let the matter be listed after reopening, my lords. We'll address your lordships.
All right.
My lord, the proceedings are complete, my lord.
and the matter is ripe for hearing. And
Okay,
if my lord can give a date in July.
Yes, 48, we'll give a date.
Lordship, there was already a direction for non-miscellaneous day in December 2024. There's an order.
Coming before us for the first time, we'll have.
Yes, Your Lordship. 20th December order already says non-miscellaneous.
Next.
Please, my lords.
Shiva,
The Google matter, man.
has he come back? Mr. Povaya.
Yes, he's logged in virtually.
Logged in, my lords.
Okay, okay. Where from?
Bye.
US?
No, my lords. I'm back, my lords. I'm back in India, my lords. I'm sorry, my lords. On the last occasion,
We'll hear you. We'll hear you. This will take some time.
Yes, please, my lords.
Time, Mr. Povaya.
Yes, my lords. If your lordship could consider immediately after vacations, my lords, on a non-miscellaneous day, my lords. Yes, please, my lords.
29. Anybody appearing?
My lord, the Army Council is on VC for action number 1.
You are in.
My lords,
I'm for.
I am appearing for respondent number 1. My lord, this honorable court had asked me